Appeal are heard in the matter of Facebook Incorporation and other and Competition Markets Authority.
Yes, Mr. Nugent.
Morning, my lords. I was on the CMA's interim measures guidance at the end of yesterday, and may I ask you to pick it up again? And can I just go back to one paragraph that my learned friend placed weight on? It's behind tab 24 of the authorities on page 1355. And you may recall yesterday that Mr. O'Donoghue placed weight on paragraph 1.7 of the guidance. And he said that this shows that remedies are really all about integration and preserving the targeted company. And I would ask the court just to look at the second sentence, which says in terms that it's to ensure the viability and competitive capability of each of the merging parties is not undermined pending the outcome of the investigation. And of course, that's not limited to whether the enterprises can stay afloat. That isn't the only question. It's whether they can carry on doing what they were doing pre-merger. And as I said yesterday, I gave you the example about digital advertising. So if Facebook had been gearing up to compete with Giphy in terms of monetizing digital advertising through GIFs or through emojis or whatever, then it might well be important that this ability on Facebook's part is preserved. And just turning back a page, if you would, to page 1354, and taking a look at paragraph 1.6, you can see there that says that the purpose of merger control is to regulate in advance the impact of mergers. And then you see this: if the CMA decides that a merger does require scrutiny, it's essential to the functioning of the UK's voluntary non-suspensory merger regime that interim measures to preserve the pre-merger competitive structure of markets should be effective. And the reason that I emphasise those words is to show the court that this is not some phrase that the tribunal plucked from the air. Now, moving on in the guidance, because I had moved forward, could I ask you...
I just turned my microphone on.
Right. So what page, Mr. Dimitri?
My lords, yes. So I was on page 1372.
Yeah.
And I've just shown you paragraph 3.22, and I'm going to show you in due course how this is reflected in certain paragraphs of the IEO, not all the paragraphs, but certain paragraphs. And then you see in the guidance, just working through, so if you could go to page 1373, the structure of this part of the guidance is that there's then a series of paragraphs dealing with different types of derogation. And so you see the heading, the large heading above paragraph 3.24, derogations generally granted by the CMA in previous cases. And then you see a small heading, you see types of derogation that are generally granted. So you see the heading further down the page, provision of essential services by the acquiring business to the target business.
Sorry, I think I'm on... Forgive me, I think I'm on the wrong page.
1373, my lord.
I was on 1377. Thank you. Sorry. Yeah, got it.
So you see there that there's then a series of examples of derogations generally granted. You see the heading there in italics at the bottom of the page. And if you would move on to page 1375, you see another example in the heading there in italics halfway down the page. And if you move on to 1377, you see yet another example. And then at the bottom of page 1377, you have guidance on more complex derogations, which of course this was the derogation that Facebook was seeking. And it's interesting to see, and it's relevant to see, how this part of the guidance is structured, because if you would turn please to page 1378 and look at paragraph 3.42, you'll see there possible justifications for such derogations, and the safeguards that may be required to put in place to support them are described further below. So this is not setting out to be exhaustive. It's providing guidance as to possible types of justification that might be used for more complex derogations. And you see the heading there, and this is important because the first heading is parts of one merging party's business that are not engaged in activities related to the other merging party's business. And you see the guidance that then follows. And the reason why, my lords, this is important is that this is the basis, and the tribunal so found, this is the basis on which Facebook made its request. So Facebook was saying to the CMA, look at this part of the guidance. Our business is not related to Giphy's business. And when Mr. O'Donoghue yesterday sought to take you back to part of the correspondence to say, well, here's the CMA considering whether or not the businesses are related, the CMA was responding to a point made by Facebook. Facebook was putting its case on this basis. And so when one's looking at the basis on which Facebook was putting its request, one then sees guidance as to what's required, the type of information that's required. And you can see at 3.43 that the CMA says it may be willing to grant derogations where it's clear that certain part of the target's business activities are not related to those of the acquiring business. A derogation on this basis will only be granted where the CMA is able to establish clearly that this won't impede the CMA from taking any appropriate remedial action that may be required. For this reason, the CMA is likely to be particularly cautious about granting derogations on this basis at the earlier stages of its investigation, where the full scope of the merging parties' activities may not yet have been fully analysed. And then you see, at 3.44, what sort of information the CMA thinks it will require in these cases to be able to analyse the situation and consider the derogations. And you see that, that their required parties are being asked to delineate the parts of their businesses that do and don't engage in activities related to each other and describe the businesses and their functions. And you have a list of, an indicative list of the type of information that the CMA wants to see. And of course, none of that was provided, not even the list of subsidiaries. And then you see at 3.46, and this is really the final point I want to make on the guidance, that's at page 1380, that the CMA says this: while the examples described above relate to circumstances in which there's no horizontal overlap between the merging parties, the CMA will also take any potential vertical relationships between the merging parties' activities into account when assessing whether derogations can be granted on this basis. And again, the need for caution. And the reason for that, my lords, is that mergers can lead to SLCs, to substantial lessening of competition, in a vertical way too. Now, you can put away the guidance and just to draw together the legislation and the guidance, which is all consistent, we say in summary that Section 72 sets a very low threshold for the CMA to impose an IEO for the purpose of preventing preemptive action. That at the very beginning of an investigation, which was the position in this case, the CMA has very little information at all. And it doesn't know, generally doesn't know, and importantly, it's not required to know under the legislation whether the merger will cause an SLC at all, still less what that SLC will be and in what market and what remedial action might be needed, because it's too early. And so what is contemplated by the guidance is that a template IEO will be imposed at the very outset to hold the ring where there's been a completed merger. And that template addresses the main types, imposes restrictions to prevent the main types of preemptive harm that might typically arise where a merger has already been completed and where there is ipso facto a risk of preemptive action because integration has taken place already. And that's contemplated by the statute too, because you've seen section 72(7), which expressly recognises that the CMA will then consider, in light of representations and information, whether to vary or revoke the IEO that's been imposed. And you saw from the explanatory notes that that indeed is the purpose of the change to the legislation.
I know it's not challenged in this appeal, but the rigid imposition of a template without consideration of the particular circumstances could be arguably reviewable as a matter of public law.
My lord, I can't say that there could never be circumstances in which that's so. So first of all, the first point to make is that it's not absolutely always the case that the CMA imposes it. So, and the guidance indicates that. So there may be circumstances in which it's absolutely obvious that there can't be any preemptive harm, in which case, obviously, if the CMA then imposed it, it would be acting irrationally. So I'm not saying, I'm not here defending the imposition of the IEO in a sort of come what may situation in every case. But in the generality of cases where a merger has been called in and the merger is already completed, then the CMA does need to hold the ring because the merger has been completed. And so if further integration happens, or if other action related to the merger happens, which could lead to irremediable harm, that would negate the purpose of the merger reference. So that's why the ring needs to be held. Now, of course, it's always got to act for the purpose of preventing action which might be preemptive. But the key point is that although that purpose remains the same, it's set out in the statute, the CMA's understanding of what constitutes or what might constitute preemptive action will obviously develop over time. And so if it imposes, coming back to my Lord's question, the template IEO and has a perfectly rational basis to do it because there's been a merger already, then and the parties come and say, well, look, this merger is all about our sort of shoemaking division, and we've got this whole other division which is related to power stations. It's totally... Then obviously if the CMA didn't act quickly to derogate, to have a derogation, that would be an unlawful act and could be challenged. So
imposing, almost automatically imposing the same template on two UK businesses, say with turnovers of 100 million merging, and on multinational businesses with billions of turnover, without giving it specific consideration to the circumstances of the businesses, would, I'd have thought, be open to question. You'd have to consider the specific businesses, wouldn't you, before you imposed even the template.
My Lord, I don't accept that for this reason, because in a sense the size of the business doesn't impact on the question of whether or not there's likely to be preemptive or there may be preemptive damage.
But size is only one of the many factors that you might have to take into account.
And so, but the real question is, what does the CMA know at the time? Does it have sufficient information to exclude that there might be preemptive action? And so, this was actually addressed in our witness evidence. Can I just show you it quickly? It's in the supplementary bundle behind tab 10 in Mr. Romney's statement at page 230.
So,
Page 230 behind tab 10 of the supplementary bundle. And my Lords will recall the reasons set out in the explanatory notes behind the reforms. And you can see here Mr. Romney explaining why these template IOs, which are, as I say, specifically envisaged by the legislative scheme, were developed. And you see there in paragraph 51, in the case of completed and non-notified mergers, it's important to recognise that at the stage of imposing an IEO, the CMA is unlikely to have available to it the necessary information that would enable it to craft bespoke interim measures, e.g. information about the extent to which the merging parties are competitors, the extent of any activity in the UK, and the nature of any links, vertical or otherwise, between the acquirer's activities and those of the target. But the template IEO is designed to specifically target those actions that may be taken by merging parties and which, in the CMA's substantial experience, are inherently most likely to give rise to concerns about preemptive action. The standard template is therefore a targeted intervention specifically designed to hold the ring and prevent action which might prejudice the reference or impede the taking of any action which may be justified by the CMA's ultimate decision on the reference. And so that's really, and it may be that the court may wish to come back and look at Mr. Romney's statement in more detail. I don't have time to deal with it all today, but we did address this. I'm asked to point you to paragraph 56 on page 231. So yes, this is the point I was getting at. So the CMA's interim measures guidance confirms that in the case of completed acquisitions, the CMA will almost always impose its template IEO on the parties, given the need to impose an IEO quickly to prevent preemptive action. Accordingly, it's very rare for IEOs not to be imposed in completed cases. However, it may occasionally be possible based on the level of information provided to the CMA by the parties at the time and the particular circumstances of the case, to tailor the scope of the IEO and examples given. And so really that's the point, that the template is designed to hold the ring at the very outset in circumstances where the CMA simply doesn't have the information. And again, I repeat the point that the statute doesn't envisage that the CMA has the information, because it's not even required to suspect a substantial lessening of competition. It's not even required to suspect that it might have jurisdiction over the merger.
Your point, the point that's made by Mr. Romney in his witness statement, if you look at the subparagraphs of paragraph 5 of the IEO, you can see exactly. I mean, forget that it's Facebook and Jiffy.
Yes.
You can see exactly the sort of activities that the IEO is designed to preclude in order to hold the ring.
My lord, yes.
You know, except in the ordinary course of business, no substantive changes made to the organisational structure or management responsibilities within the businesses, and so on and so forth.
My lord, yes, because to take the example that my lord, the Master of the Rolls, pointed to yesterday about the Facebook sticker library, which wasn't drawn to the CMA's attention at the outset. That's something that it didn't notify the CMA of in its merger notice. And the CMA then realised that this library did exist. Then that's the kind of thing that the CMA needs to preserve in case it's important later, once it's analysed the competitive situation in the market. And so that's why the IEO targets things like retaining key staff, not selling off assets that might be the means used to build the sticker library. So it's targeting the tools the business uses to make changes which might be preemptive. That's how it all works. Now, may I turn now to the IEO itself, please? So this is behind the tribunal, behind the tribunal's judgment, at page 155. And before I do that, it's probably a good time to answer a question put to me by the court yesterday, which is, has there been any other challenge to this type of information request? And the answer is not to the CMA's knowledge. The current staff can't recall any such challenge to an information request, any legal challenge to an information request. And we should point out that there are other large companies like Facebook, for example, Google is a recent example, which has been faced with the template IEO and has negotiated derogations by providing the CMA with material. Now, this is not to say that parties don't make representations to the CMA about the scope of derogations and what information is necessary. Of course they do. But that is that's in the context of cooperating with the CMA to reach an answer, which is not the situation we had in this case. So, my lords, going back to the IEO at page 155, the first point I just want to make in passing is that this is not the carve-out request that Facebook is currently asking for. So I think Mr. O'Donoghue did, I think probably by mistake, say that in his submissions yesterday. But Facebook submitted a revised and narrower request in November last year. And so that one, the revised request, is not, of course, relevant to this appeal because it postdates the events we're talking about. But it is important in the sense that my learned friend repeatedly made submissions yesterday about the CMA abandoning its position, and we don't accept any of that. Things have moved on, including the request that Facebook has made itself. But anyway, it's this carve-out request that's relevant to the present appeal. And I just want to draw the court's attention to a couple of features. So turning to paragraph 5 on page 156, you'll see that what Facebook wanted is, for example, a carve-out from paragraph 5C So except in the ordinary course of business, no substantive changes are made to the organisational structure or management of, and they wanted that not to apply to the Facebook business as a whole. And you see, similarly in E, the same deletions. But then in D, they accepted that D would apply to the Facebook business insofar as those parts of the Facebook business, they say, relating to the procurement or supply of gifts and stickers. So they're accepting that parts of Facebook's business should continue to be in this part of the IEO. And this is something that the CMA needed to understand, as I'll come on to. Now, another feature is that you see that at D, 5D, sorry, at paragraph 8, which relates to key staff, part of which relates to key staff, you see that 8A, details of key staff who leave or join the Giphy business or the Facebook business, that's maintained. So they're not seeking to delete the Facebook business from 8A. So you can make your points in reply, I'm sorry. So you can see at paragraph 8A that they're seeking to keep details of key staff who leave the Facebook business in the scope of the IEO. But if you turn back to 5...
Well, I'm sorry, it's a duty to inform.
Sorry?
You see from the body of it, it's a duty to inform. It's not a duty to request a derogation.
Duty to inform.
Right, duty to inform, that's quite right. So then you look at, you look at the previous page and you see that changes to key staff are deleted. And so again, there's a certain inconsistency between those things that the CMA needed to understand. But really the broad point that I'm making is that in order to understand this request, it was essential for the CMA to understand both how Facebook's business was organised, changes at 5D. It envisages that those parts of the Facebook business relating to the procurement or supply of gifts and stickers is within 5D. So obviously the CMA needed to know what Facebook meant by those parts of the Facebook business. It didn't have a clue. And we explain this point, I think I can take it most efficiently from our skeleton argument, paragraph 27, which is on page 61 of the core bundle behind tab 4. And so we say there that in order for the CMA to make any meaningful assessment of this proposal, it needed to understand, and we list the things it needed to understand. So at A, the extent of its related business with Giphy, and whether it was appropriate to confine it to the procurement and supply of gifts and stickers. What's meant by gifts and stickers? What's Facebook's understanding? What's the CMA's understanding? Then at B, and this is important, to the extent the definition of related business posited by Facebook was appropriate, precisely what areas of Facebook's business carry on that activity? At the time of the hearing before the tribunal, Facebook had never clearly explained which elements of its business relate to the procurement or supply of gifts and stickers, and which do not. Indeed, the information it had provided in this regard was contradictory and confusing. And so you see there that Facebook's draft merger notice, which was submitted on the 3rd of July, explained for the first time that each of Facebook's primary or core services had an API connection with Giphy. And so on the basis of that, the CMA was completely entitled to assume that businesses related to the supply and procurement of gifts and stickers include those core services. But then you see at B that Facebook never explained to the CMA how it proposed that these vertical links between its core services and Giphy would map on to the concept that it was proposing in the carve-out request. And it was only in its reply evidence before the tribunal that Facebook confirmed for the first time that it didn't intend the concept of activities related to the procurement or supply of gifts and stickers to capture the activities of its core services. That simply wasn't clear to the CMA before Facebook's reply evidence to the tribunal. And this really is illustrating why the CMA needed information, which Facebook intransigently just refused utterly to provide. Now, I want to take you just to one paragraph of the tribunal's judgment at this stage, which is paragraph 125 on page 140. And this goes to the point I made a few minutes ago about Mr. O'Donoghue's reference to part of the correspondence. So he was saying this correspondence showed that the CMA set us up to fail, were his words yesterday, fixated on links between the businesses. Well, my response to that is that the tribunal found that that wasn't so, and that the reason that the CMA was asking about that was because it was the basis on which Facebook made its request. And you can see that from the amendments to 5D itself, and it's abundantly clear when one looks at the entirety of the correspondence. And you see the tribunal's finding at page 140 of the bundle, paragraph 125. The tribunal, and they're confronting the point made by Mr. O'Donoghue yesterday. The tribunal does not accept the applicant's characterisation of the CMA's correspondence as evidence that the CMA misdirected itself. The context shows that the CMA was acting responsively to the letters from Latham and Watkins and the assertions set out in them. In particular, there were no horizontal overlaps between the activities of Facebook and Giphy. The CMA's letter of August makes clear it has not reached that conclusion yet, and in any event, it will need to assess the vertical relationship between Facebook and Giphy when determining the carve-out requests. The CMA's correspondence explained that the connection between its assessment of any horizontal or vertical overlaps and the provisions of the IEO relates to the CMA's concern to preserve the competitive structure of the market. So that's the context in which all of that arose. Facebook was putting its request on the basis of the paragraphs 3.4 and 3.43 and 3.44 of the guidance, no links, unrelated business, and the CMA was simply probing that assertion. Now, finally, my lords, on the facts, before I turn to the grounds, and I'll be able to make my submissions on the grounds, I hope, efficiently. I do wish to make clear that the CMA does not accept the wholly partial account of the events since the tribunal's judgment that my learned friend put to the court yesterday. He sought, amongst other things, to present the CMA as having abandoned its position and having unjustifiably delayed in granting Facebook's request. And it's very important, on behalf of my client, that I put on the record that the CMA does not accept this as a proper or fair characterisation of what has taken place. Indeed, the CMA's perspective is that it is Facebook that has consistently delayed in providing the information that the CMA needs to progress this. Now, this of course, as the court noted yesterday, is not a matter that the court either needs to resolve in these proceedings or possibly could resolve in these proceedings. But if the court thinks that it's necessary to understand the CMA's perspective on recent events, I'm not going to turn it up, but can I give you a reference to a very recent letter from the CMA which sets it all out, sets out its perspective on the events since the tribunal judgment, and it's in the unagreed bundle from page 229 onwards. Now, we also say that the court should not assume that the CMA accepts the various points made yesterday by my learned friend about the underlying transaction itself. And we've explained this fully in our skeleton argument, so I don't need to say much more now. And the tribunal, of course, was properly very astute to steer clear of those matters because they are matters for the investigation.
The subject of the Phase 2 investigation now.
Exactly.
So,
precisely.
quite apart from the fact it's not the subject of any of the grounds of appeal, the court couldn't possibly begin to do.
My lord, I completely agree, but I just want to make clear that we don't agree with the assertions, just in case the court thought they were common ground.
We did really tackle Mr. O'Donoghue on that topic yesterday.
My lord, you did, and I don't think I need to press it further, but just to say that on Facebook's own case, if one looks at their skeleton, footnote 1, the 1% figure, which was bandied about yesterday, is actually, when you look at Instagram, it's 6%.
6% for Instagram,
6%.
yes.
So even on their own
2%,
case, one has to take with
2% for another platform.
That's
yes,
ignoring the point that Master of the Rolls made yesterday about businesses expanding.
My lord, yes, I'm not going to press that any further. I just wanted to express my concerns. So I'm going to turn now to the grounds and to ground 1. Now, of course, the court will know that by its first ground of appeal, Facebook seeks to argue that the tribunal's conclusion rests on a legal error as to the proper interpretation of preemptive action in section 72, subsection 8 of the Enterprise Act. Specifically, Facebook argues that the tribunal wrongly took the view that section 72(8), gives the CMA some kind of roving brief that permits it to prevent any action that might affect the competitive structure of the market, regardless of whether this is connected in any way to the merger. That's their submission. And I have two submissions to make in response. The first submission is that the tribunal's decision was based on its finding that the CMA was not in a position to assess the carve-out request and the risk of preemptive action that might arise from it, due to Facebook's intransigence in refusing to provide the CMA with the necessary information. That was the basis for the tribunal's decision, and it is irrelevant to that finding whether any particular form of preemptive action would fall under limb 1 or limb 2 of the definition in section 72(8). The second submission is that in any event, Facebook has mischaracterised the tribunal's judgment. The tribunal did not conclude that the CMA has power in making an IP's activity which is unrelated to the merger in any way. It would be very surprising if the tribunal had held that, and it's clear from reading the tribunal's judgment as a whole that it did not. And so we say, for both of those reasons, Facebook's first ground of appeal is attacking a straw man. Its appeal is completely sterile. So I'm going to take those submissions in the order in which I summarise them. And in relation to the first submission, the first and critical step in my submission is to identify why the tribunal found that the CMA had acted lawfully. And it found it acted lawfully because Facebook failed to engage at all with the CMA. That really is the crux of the tribunal's reasoning. And Facebook's first two grounds of appeal completely sidestep this fundamental point, which is why I say that they're really sterile grounds of appeal. And the tribunal's conclusion was correct, because the starting point...
That part of it is not challenged.
Not challenged. And the starting point of the tribunal is that the CMA imposed the template IEO. The starting point in events is that the CMA imposed the template IEO, and Facebook rightly does not challenge that. So Facebook doesn't argue that when the CMA imposed the IEO, Section 72 required it to reach a view as to what remedy was likely at the end of the process and satisfy itself that each specific part of the IEO was tied into some remedy that might be appropriate on the facts of this case. And such an argument would plainly have been wrong because of the point I made about the statutory scheme, which is that the CMA is not in a position to and is not required to reach a view on those things at this point in the investigation. So is not challenging the imposition of the IEO. What is it challenging? It's seeking to argue that the CMA's failure to grant its request was unlawful. And why did the CMA fail to grant its request? Well, this is the point that's been determined by the tribunal and hasn't been challenged. The reason that the CMA didn't grant the carve-out request is nothing to do with the meaning of the first limb of Section 72(8). Nothing to do with it at all. It was that Facebook did not provide it with the information it needed to assess it. It didn't provide it with any information. It decided to take a point of principle, and it failed completely to cooperate. Now, in seeking further information, the CMA acted lawfully. The tribunal was obviously right to find that. And in determining, as an expert regulator, in determining what information it needs, the CMA has a wide margin of discretion. And I would like to come back to the BAA case, and it's a point that was that was highlighted by Lord Justice Phillips yesterday. So it's in the first authorities bundle behind tab 7. I might just take you to paragraph 300, to page 310. I am going to come back to this judgment under the final grounds of appeal, but I just want to make one discrete point now, and it's a point that emerges from subparagraph 3 of paragraph 20 on page 310. And this principle, and you can see the various authorities that underpin the principle set out by Mr. Justice Sales, as he then was. You can see those listed. The principle is widely accepted and has been endorsed in various cases, which is that the CC, now the CMA, as decision maker, must take reasonable steps to acquaint itself with the relevant information to enable it to exercise its statutory functions. Had to in this case, it had to in this case, and it did in BAA. And you see reference to the well-known Tameside case, where, of course, if public authorities don't take adequate steps, they're acting unlawfully. That's what Tameside establishes, a very well-known public law principle. And you see further down, the CC must do what is necessary to put itself in a position properly to decide the statutory questions. And then this, the extent to which it's necessary to carry out investigations to achieve this objective will require evaluative assessments to be made by the CC as to which it has a wide margin of discretion, as it does in relation to other assessments to be made by it. And then you see, in the present context, we accept Mr. Beard's primary submission that the standard to be applied in judging the steps taken by the CC in carrying forward its investigations to put itself in a position properly to decide the statutory question is a rationality test. And then you see reference over the page to the well-known Catton authority. The court should not intervene merely because it considers that further inquiries would have been desirable or sensible, should only intervene if no reasonable relevant public authority could have been satisfied on the basis of the inquiries it made.
So the obverse must be true.
The obverse must be true. In fact, the obverse is a fortiori.
Yeah.
So we say that it's a rationality standard. And of course, the court can't possibly, as it were, stand over the shoulder of the public authority, of the regulator, saying, well, this bit of information, paragraph 5 of this letter seems to go a bit beyond what's necessary, because quintessentially it's the regulator that's best placed to decide what it needs on the basis of its experience to determine the standards. Now, we say that that the CMA plainly acted rationally in seeking further information in this case. As it's consistently said, it will consider requests for derogations as quickly as it can, but it needs evidence and information in order to do that, because at the early stage it simply doesn't have that information. Now, in this case, of course, the carve-out request was extremely wide-ranging, seeking to exclude from most of it the entirety of Facebook's business. And you have the factual point I've made, which is that the request itself, if you look at paragraph 5D, relies on an understanding of what's meant by those parts of Facebook's business that relate to gifts and stickers. So these are all things that the CMA needed to understand. But there was a wholesale failure, as I've said, and as the tribunal found, more to the point, by Facebook to engage with the request that it provide the CMA with information. And so we say that not only was the CMA's action rational, it was wholly appropriate for it, as the tribunal found at paragraph 128 of its judgment, wholly appropriate for it not to simply rely on Facebook's assertions. And one can test it this way, in a sense, by turning the proposition round. So what if the CMA had said, okay, Facebook, we take your word for it, that there are sections of your business that are just not related to gifts and stickers, and all of that can be excluded. In fact, we can exclude all of your business from most parts of this IEO. And then a third party had come along and said, well, hang on, they're now damaging the market as a result of this completed merger. Aren't you going to do anything about it? And if the CMA had said, well, we took their word for it, there would have been a plain Tameside challenge that the CMA hadn't done what was required. It's easy to see. And so there is, in sum, nothing unlawful about what the CMA did. And that was the real reason, the actual reason, why the tribunal dismissed Facebook's appeal. And as I say, the meaning of the first limb of section 72, subsection 8, simply doesn't have a bearing on that question, which is why I say this is a straw man ground of appeal. But I'm going to turn now to the second submission, which is that the tribunal did not, in fact, misconstrue section 72. And could we please turn back to the judgment, to paragraph 124, which is on page 140. Now, my learned friend seeks to take the third sentence in isolation, as it were. That's really how he makes his submission. And the first point to make is that it's clear from reading the paragraph as a whole, and of course it must be read as a whole, that the third sentence is conditioned by the second sentence. And the second sentence says that the definition of preemptive action includes action which might prejudice a phase 2 reference. So it's tying it in to prejudice to the merger reference. And then you see this includes, so a subset of that is harm to the competitive structure of the market. And we can see that that's what the tribunal meant.
So you got the right numbers. I think you were talking about the third and fourth sentence.
You are right. It's the third and fourth. I'm so sorry. So the fourth sentence is what they rely on. Yeah. And I say that it's conditioned by the second sentence. So in a sense, to put it mathematically, the fourth sentence is a subset of the third.
Well, the argument here is, Mr. O'Donoghue's argument is that when it talks about prejudicing the reference, it's effectively limited to procedural issues and not to substantive issues.
Yes, and we say that.
You say, well, that's just wrong.
It's just wrong.
There's nothing in the wording of the statute that suggests that it's limited in that way.
That's exactly right, and so his submission, we say, is simply inconsistent with the statutory language. You would expect to see something like would prejudice the merger reference procedure, or the procedure by which the merger reference is conducted.
Process or something like that.
Process, but there's nothing like that. It's talking broadly about the reference itself. And so, in my respectful submission, it's doing damage to the breadth of the test and the statutory language to interpret it in the restrictive way that my learned friend suggests. Now, my lords, can I just show you why I say that it's crystal clear that the tribunal wasn't misdirecting itself? And could you please turn to paragraphs 21 and 22, which...
Of the judgment.
Of the judgment. Which you'll find starts on page 93. And here, this is in a section where the tribunal's setting out its understanding of the statutory scheme. So it says, the purpose of merger control is to regulate in advance, so it also avoids ex ante, regulate in advance the impact of mergers on the competitive structures of markets. Within the UK's voluntary notification regime, interim measures play a vital role in allowing the CMA to ensure that, other than certain steps taken in the ordinary course of business, a merger and the actions of merging parties do not impact the pre-merger competitive structure of the market during the period of the CMA's investigation. So it's clearly looking at the merger and the actions of the merging parties. Preserving the competitive structure of the market is not just concerned with the ability to restore the position of the acquired and acquiring businesses. It also includes preventing anti-competitive harm, and then I'm emphasising the next words, from the merger transaction, impacting the position of other undertakings on any affected markets which may be irremediably detrimental. Such undertakings could include competitors, suppliers, or customers of the merging entities. And then you see at 22, so just pausing there, it's clearly envisaging a connection between the anti-competitive harm to the structure of the market and the merger transaction. It's crystal clear in my submission. And you see the same from paragraph 20.
It's not talking about markets generally, it's talking about the affected market.
The affected market. And it's
affected markets, because there may be markets that are not, as it were, directly impacted, but are indirectly impacted.
My lord, quite so. And at that stage, precisely what markets are impacted. And it's also...
And that ties in with your tentacles point.
It ties in with my tentacles point. And my lord, you see the same point from really the same point being made clear in paragraph 22, And you see the second part of that paragraph, in such a case, any harm arising from the merger transaction may subsequently be difficult or impossible to remedy. And so it's clear that the tribunal is talking about harm arising from the merger transaction. And that's the context in which paragraph 124 arises. And what the tribunal was doing was accepting a submission that I made on behalf of the CMA, which is noted in paragraph 108, which is on page 134 of the bundle. And we were responding to the submission made by Facebook, which is repeated in ground 2, that so long as you preserve Giphy, to preserve what they say is the worst remedy that could happen, which is divestment of Giphy, that's all that's needed. And that indeed they say that the IO is unlawful, necessarily unlawful insofar as it goes further. And we were saying no, because the definition of preemptive action is broader than that. And we were making this point about action that might be taken as a result of the merger, which affects and harms the market in the meantime, which can't be remedied at the end. So abandoning relationship with tenor was the example we gave, and that's really the point that the tribunal is addressing. And so that's why we say that there is no error in paragraph 124.
Well, somebody goes out of business as a consequence of the merger, for example.
That's right. So let's say...
And it's simply not possible 2-3 years down the line to reconstruct the business because it's gone.
Exactly. And so divesting Giphy isn't going to affect that. It's gone and the market's been damaged as a result of the merger. Mm-hmm. And that's exactly the sort of point. So, so my Lord, the Master of the Rolls, asked me yesterday for our considered view as to whether we would amend paragraph 124. So I'm going to give you my answer. So we say, for the reasons I've given, that it actually doesn't need amending. But since we've got to the Court of Appeal on this point, and Facebook purports to identify some lack of clarity, may I just suggest an amendment that would reflect paragraphs, the earlier paragraphs of the Tribunal's judgment. And if you turn back to paragraph 124 on page 140, and the fourth sentence, it could usefully be clarified to say something like, as the CMA submitted, this includes action related to the merger that has the potential to affect, during the course of the investigation, the competitive structure of the market or markets that may be the subject of the CMA's investigation. So
I didn't quite get that down. But
let me say it again, my Lord. So we say that if you could amend the fourth sentence to say, as the CMA submitted, this includes action, and then insert the words related to the merger that has the potential to affect, and then insert the words during the course of the CMA's investigation, the competitive structure of the market, and then insert the words or markets.
During the course of the CMA's investigation, then what?
The competitive structure of the market, so that's in there already, and then add the words or markets, plural, that may be the subject of the CMA's investigation, full stop.
But you say that's just for clarity.
Just for clarity. There's absolutely no error.
But it has to be read as I think you've just submitted alongside paragraphs 20 and 21, which explain the structure.
My Lord, quite so. And it would be very odd if the tribunal had said that it doesn't need to be related to the merger, because the statutory language says prejudice the reference. So obviously it has to be related to the merger.
I think one of the problems perhaps is that Facebook's submissions seem to be on the basis that it's only 3 or 4 paragraphs of this judgment that is relevant. But actually, when you read the judgment more carefully, although there are large passages about submissions, which one may not think was quite necessary, there are also substantive paragraphs in the earlier part of the judgment.
My Lord, that's quite right.
So they're a bit scattered. I mean, I'm not being critical, but they are a bit scattered, and you need to put them together in your mind at least. to understand it properly.
My Lord, we quite agree, and it's very clear looking at the tribunal's description and findings as to the statutory scheme in that earlier part of the judgment that it got it completely right. So it's
Well, it's
really
not.
correct.
It's not criticised.
It's not criticised. And so what one can't do, and it's unfair to the tribunal, is to pick a single sentence later on in the judgment where the tribunal's made quite clear that it knows how it all works, and say, well, it's misdirected itself. It's simply not a proper way to proceed. Now, I think that's all I need to say about ground one. I think I've covered my submissions on ground one. I can be very, very quick on ground two because I've really, in making my submission so far, covered the territory on ground two as well. Can I just summarise in a nutshell what our response is? So Facebook's argument is that there is no conceivable basis for freezing its global business with a view to preserving the CMA's remedial options, because it says the most extreme remedial option that the CMA could adopt is divestment of Giphy. And our answer is that that assertion, that approach, is flatly inconsistent with the statute, because the court's seen in Schedule 8 the range of remedial powers that the CMA has. They're not confined to divestment, and they're not confined to the target business. And similarly, Section 72 is framed in broad terms in relation to any action which may be justified by the CMA's decisions on the reference. And so to focus only on the divestment of the target company is wrong. It's restricting the powers that Parliament has given the CMA. And indeed, we've made the point in our skeleton that the CMA must act proportionately. So if it considers there's another remedy that would do the job short of divestment of Giphy, then it's got an obligation to order that.
And where's the paragraph in the decision that is relevant to ground two?
The paragraph in the judgment?
Yes.
I think that the grounds before, it may take me a moment to find it, because the grounds were not put in quite the same way below.
No, they weren't. That's why I'm asking.
Can I just ask my junior to answer that?
But she can take her
thank you.
time and tell you in a minute.
So, just to...
Well, the way it's put in the ground is that the tribunal failed to address the point, so it may not be in the judgment.
Well, my lord, it really was front and centre of their argument below. They didn't stop talking about how divestment was the... I mean, I think we'll find the relevant parts in the judgment.
I think they did address it, actually.
Yeah,
They did address
that's why I'm...
But I'm just not sure that... I just wanted to have it in my mind where they did it, if you don't mind.
No, of course. But in terms of our response, we say that to say divestment is the most extreme remedy and to focus only on that is wrong in principle. And we've made the point in our skeleton argument that this is not... The CMA doesn't always order investment. It's got these broad powers and it sometimes uses them, and it needs to keep them all in play. That's the purpose of holding the ring. And if you turn to paragraph 41, please, 49 of our skeleton on page 71, you'll see at little c, we've given a recent example in Bauer Media Group of the CMA imposing behavioural remedies. And back to the sticker store example that we were debating a little earlier, divestment of Giphy, of course, would not prevent that type of harm. So let's say that Facebook pre-merger had been actively developing its sticker library to compete with Giphy. Let's say those had been its plans pre-merger. And of course, at that stage, the CMA just didn't know. And then, of course, post-merger, its incentives would change because it had acquired Giphy and it would no longer, it may not have an incentive to continue to develop its sticker library. And so it shelves all of that. And then you have a merger reference, which says that this merger causes SLCs and needs to be remedied. Well, let's say that the CMA does order divestment of Giphy. That doesn't address the problem, the harm to the market, which is caused by Facebook dropping out of the market in competition with it. So that's why Facebook's view of the world doesn't reflect the CMA's powers or the legislation.
The divestiture point maybe 137.
Yeah, that's what I think is 137.
137.
I got to 137. We all had.
151 is also relevant, I
Thank
think,
you.
because that says that that talks about the fact that preserving the divestiture of Giphy was premised on a narrow view regarding the limits of the CMA's remedial options.
Thank you very much. It was Yeah, so I'm told that our submissions were at para 109, page 134. And you can see that the argument there, you can see a flavour of the argument, because I'm there addressing an argument that that's repeated before this court, that there's some kind of legal principle that the CMA can't do anything more than order divestment of the target business. So that's what was argued. And again, I made the same argument there that I'm making to my lords now, which is that the CMA has a wide range of remedial options available to it. And that's the argument. And then I think that particular ground wasn't separated out from the first question of what's meant by preemptive action in the way that Facebook then put the case. There's not two separate headings, as it were. The tribunal looked at it all in the round.
Yeah.
So, my lords, that, unless you have any questions, is what I say about ground 2. It's really part of grounds 1 and 2 are really linked very closely. And then I turn now to ground 3. And by ground 3, Facebook challenges the finding of the tribunal that the CMA wasn't obliged to release Facebook from the specific obligations contained in para 5 of the IO because para 4 existed. That's its challenge. And really, this was, in my respectful submission, dealt with impeccably by the tribunal at paragraph 131 of its judgment on page 143. And you can see there that the tribunal is saying it's not desirable or ideal to grant a derogation to an IO provision on the basis that there's a broader provision within the IO that catches all preemptive action. It's Mr. Romney's evidence, which the tribunal accepts, that the provisions in the template IO are designed to specifically target those actions that may be taken by merging parties, and which in the CMA's substantial experience are inherently most likely to give rise to concerns about preemptive action. The tribunal is not persuaded, therefore, that in the circumstances of this case, where the CMA has reasons for concern, it's an answer to those concerns to say that there are broader fallback provisions within the IO that can give it comfort against the risk of preemptive action. Furthermore, it's important that merging parties, the CMA, and in the case where one has been appointed, the monitoring trustee, know with clarity what the parameters are in respect of actions that are prohibited, required or allowed under the IO and any derogations, and that each side knows what to expect from the other. Not sufficient that Facebook understands what it means and the implications of its carve-out request if the CMA and the MT do not. There are practical implications of Facebook's approach in the context of the current position with the IO. And so, in a way, it was a very ironic submission that was being made, because one of the other grounds of appeal that was advanced by Facebook below but not here is that there was a legal certainty problem with the IO. It didn't know what it had to do. And that, in my submission, that any question of legal certainty, that's why paragraph 5 is there, to make it more clear and not leave it to the judgment of the merging parties what they can and can't do. And indeed, the very fact we're here before the Court of Appeal arguing about what's meant by preemptive action shows you the danger in doing that. And just finally on this point, if you could please just turn back one last time, I hope, to the statute and to section 72. So we're tab 21 of the authorities, page 1190, 72 subsection 2. You can see the way it works. So 72.2, you've got to have the purpose of preventing preemptive action, which is subject to the definition at 8. But then at B, the CMA may impose on any person concerned obligations as to the carrying on of any activities or the safeguarding of any assets. So this shows you can do what the CMA's done in paragraph 5. So the things that you're asking the merged undertakings to do, so don't sell part of your business, don't let key staff go, don't stop important contracts, those are all activities which might themselves give rise to the risk of preemptive action. So that the Act specifically envisages that this is a legitimate way to proceed. And so in a nutshell, my lords, if the only obligations which Facebook were required, or which any merging parties were subject to, were those at paragraph 4 of the IEO, there's a significant risk that they would be certifying their own compliance in circumstances which the CMA would regard as giving rise to a risk of preemptive action. So it leads to the risk of a mismatch between what the CMA's understanding is and what the understanding of the parties is. So, my lord, I'm now turning to the final ground 4, unless you have any questions for me so far. So, by its 4th ground of appeal, Facebook contends that the CMA's requests for further information were disproportionate. And this ground has evolved somewhat, so the way it was really put in their skeleton took the form of a complaint that the tribunal had failed to consider this question. And that's unsustainable. The tribunal did squarely address the argument at paragraphs 148 to 155 of its judgment. Now, it became more apparent yesterday that the point that my learned friend is really making is that the tribunal didn't apply the right level of scrutiny. So he says that the tribunal should have applied a proportionality standard in looking at whether the information requests were lawful. And in fact, they applied a rationality standard because they said that in this context, proportionality and rationality come to the same thing. And he says that that's unlawful. And we say that that's not unlawful. It does actually come to the same thing, as the authorities show. But really, the first stage in my respectful submission in addressing this ground of appeal is to ask, what is the decision that Facebook is complaining about? That's critical. And the tribunal found, and again, if I could ask you to turn up paragraph 148 of the judgment at page 148, the tribunal found that the decision that Facebook was complaining about really was the CMA's decision to seek further information. That was why it wasn't immediately granting the carve-out request. And we agree that that is the decision that they're really targeting under this limb, and Facebook hasn't disputed that. And so then if that's correct, then the second stage is to ask, well, what are the legal constraints on the CMA when it decides what information request to make? And you're squarely then within BAA paragraph 20, subparagraph 3. It's the converse of Tameside. So the standard is one of rationality. The CMA has a wide discretion in determining what information it needs to decide the statutory questions. And so my submission is that the tribunal could have stopped there. It could have said, well, this is a rationality question. But in fact, it didn't stop there. It did go further and also considered the proportionality of the CMA's actions under what was then ground 2. And we see that from paragraph 148 itself. So you see that the tribunal specifically considers proportionality. And you see the conclusion at 155 on page 150. So accordingly, the CMA's request for information in order to determine the carve-out request was not disproportionate, and its decision not to determine them without further information was not irrational. So it's considered it on both bases. It really can't be criticised. And when you turn to BAA, which if we could just turn that up one final time, so it's Authorities tab 7, this time page 311. You see at paragraphs, subparagraphs 5 and 7.
Sorry, I'm a little bit behind you.
So sorry.
25 and 7.
Yes, so it's page 311. You see
Yeah, got it.
subparagraph 5. Mr. Justice Sales, as he then was, has already explained the position in relation to what information is needed. That's rationality. That's subparagraph 3, and we say that the tribunal could have stopped there, but it didn't. It considered proportionality. So then the question is, well, what does proportionality mean in this context? And you see at 5 that what it means is, in this context, where the CMA is the expert regulator, where these are tricky questions of economic assessment, what it means is the same as rationality, essentially, manifestly without reasonable foundation. Now, and you see that explained. So you see that, at the bottom of page 311, where social, so this is Daly, the well-known dicta of Lord Steyne in Daly, where social and economic judgments regarding the existence of a problem of public concern, warranting measures of deprivation of property, and if the remedial action to be taken are called for, a wide margin of appreciation will apply, and subject to any significant countervailing factors, the standard of review will be to ask whether the judgment in question is manifestly without reasonable foundation. And so you see there, and then over the page, there's more of the same. And then at subparagraph 7, you see exactly the same reasoning. What Mr. Justice Sales, as he then was, is saying is that the ordinary rationality standard is flexible and can be adjusted to take account of the contextual factors. Now, what did Mr. O'Donoghue say about that? Well, he said he sought to suggest that these paragraphs, the principles in these paragraphs, are not applicable because the case can be distinguished. But of course, we're not saying that the case is not saying that the same. It wasn't about preemptive measures, but what Mr. Justice Sales, as he then was, distilled were a series of principles which are rooted in many other authorities about what proportionality means in a context such as this. And we have addressed that at paragraph 60 of our skeleton argument on page 76 of the core bundle, which I'd ask you just finally to turn up.
Paragraph
60. So we've addressed this complaint that Facebook is not happy with the intensity of the proportionality review. And then you see what we say there is that BAA, which is cited by the tribunal and by other courts dealing with merger cases, these are the standard principles which are applied by the courts, that essentially the standard of review required by A1P1, where that is engaged, is equivalent to rationality. And that's because the CMA is engaged in the formation of social and economic judgments regarding the existence of a problem of public concern, warranting measures of deprivation of property and of the remedial action to be taken, the words from BAA. And you see over the page more recent authority making the same point, so the Joint Council for the Welfare of Immigrants case, that in contexts such as this, where a regulator is expert and has a wide discretion, there is actually no difference between the intensity of review that is required.
But on one view, this is all very interesting, but completely academic, because if you're right in your primary position, that the decision that was being complained about was the request for further information, that's at the investigation stage, which is dealt with by Mr. Justice Sales at paragraph 20, subparagraph 3.
Exactly.
Where the relevant test is clearly a rationality test.
Exactly.
Full stop.
Exactly, that's my
So
primary...
this is all, even if this part of BAA were wrong, paragraph 20, subparagraph 5, and you say it's not wrong because it's been applied most recently in the Ecolab, so what?
My Lord, precisely.
Because this is not a final decision.
Precisely, and that's why I say the tribunal could have happily stopped at 20 paragraph 3. And my Lord, just one further point, which is that we're not here facing a challenge to the precise nature that would have been very onerous to respond to paragraph 5D of the information request. They did nothing. So that's really the point, and that's why all of this sidesteps the basic finding of the tribunal. And in a sense, this whole appeal, all of these grounds of appeal, are sidestepping that finding of the tribunal. And they just simply don't engage with it.
My understanding is of the effect of 7 is, in fact, that the analysis would be that if you're taking a seriously intrusive step, then you would expect the inquiry proportionality would require a greater investigation, not a lesser investigation.
That was the context there, and so, and that is exactly so, my lord. And here, so Mr. O'Donoghue sought to say, well, it's a more intrusive review, where it's the opposite, where the CMA is actually actively trying to get to the bottom of it. But that can't be right. It can't be right. It's, if anything, it's the other way around, that the CMA should be accorded more of a margin of discretion when it's trying to acquaint itself with the facts.
Yeah. Yeah.
My lords, I've come to the end of what I wanted to say. Those are our responses to the grounds of appeal. I'm very happy. I'm a bit early. If you have any questions, I'm very
Being
happy.
early is not a criticism.
Anything
Anything else?
No.
Thank you very much, Mr. Mitchell. Mr. O'Donoghue.
Well, I'm in your hands. I'm conscious yesterday we had no break for the transcribers. But I'm in your hands. I'm obviously happy.
Sorry?
I'm conscious that yesterday we had no break for the transcribers at all.
No, I never take a break when we're sitting in court.
Ah.
It's very tough for the transcribers, but they just have to
Well, I'm in
bear
your
with
hands,
it.
of course.
It's different when we're
Yes.
remote.
Yes. Screen time is one thing, but transcriber time is another.
My lords, I see the time. I won't treat lunchtime as a target. I will try and stick
Well,
to
you can
stick to my hour.
take your time, Mr. O'Donoghue. There are some serious issues for you to deal with.
My lord, yes. My lords, as a starting point, the legal issues raised in this case are of fundamental general legal importance to all stakeholders in UK merger control, which includes, but obviously is not limited to, the CMA itself, and of course international M&A activity. We know the CMA is now almost always imposing its standard template, IEO, on completed mergers, and then subjecting the parties to a derogation process. That is not required by the legislation. It was the CMA's choice to do so. And Mr. Mitchell at times came quite close to saying that the statute effectively requires that. It doesn't. It's a choice. It was a choice which was exercised, it seems, from 2014 onwards on the CMA's part. Now, we don't criticise them for that, but it is not a requirement of the legislation. It is purely a choice on their part. Now, significant concern has been expressed about these developments by stakeholders. Just to give you two references from the bundle, the first is supplemental to tab 36. That's a bad reference, I think.
Yeah. That is a wrong reference, isn't it?
Yes.
There are only 28 tabs in
Yeah. Sorry? Sorry, authorities to, not supplemental. My tab 32 in authorities.
Sorry. Authorities.
To tab 32.
What's the authorities? Tab 30.
32.
What is it you're trying to refer us to?
Well, we can start with tab 32. In the authorities.
Heidemann and Notovich. Interim orders in UK merger control.
Yes, it's that article, my lord.
Right.
1655. So this is an article by a former CMA merger official. And if the court can see that at the top of 1655, an IO imposes significant burden on the entire business because its terms not only prohibit integration with the target business, but also impose a freeze on certain activities, even for those parts of the business that would have remained unaffected by integration, and so on. And then the next paragraph, so there's a concern about it being unnecessarily wide, you see at the end of that paragraph. And one way of achieving this would be to limit the scope of the IO. For example, activities which are in an area which overlap arises between the acquirers and the target's business. Then it notes various practical problems. So that the concern has been expressed in public, including by a former CMA official.
Well, the next sentence is quite important.
The whole of this is to do with the imposition of a template IEO, and this, as my lord says, the last part of that second paragraph is making it clear why it's necessary, because of the asymmetry of information.
Well, it does say that. It makes 2 points. One, these impose a significant burden, and second, 3 points. It could be limited to overlap, but there may be a practical problem in doing so.
Well, at the point where the CMA knows nothing, at the beginning of June of last year, it couldn't possibly have limited to overlap.
Well, I accept day one or the early days may be one thing. By the time we had the CAT hearing, we were 4 months into the investigation. That may be a different thing. The second point.
Hang on a moment. The CAT judgment, as we put to you several times yesterday, proceeds on the assumption that you had failed to comply with the request for information, full stop. What's happened since is neither here nor there, but my lord, the Master of the Rolls, referred you several times yesterday to those paragraphs towards the end of the CAT judgment at 158 and following, as to 159, where dealing with the fact that you failed to engage.
Well, I will deal with that. I haven't ducked the point.
But it's not part of your appeal, with respect. There are factual findings that are made against your client that are not part of the appeal.
Well, I will come to that. I do have a response to that. And so that's by way of introduction. Now, the court should also appreciate that the trigger in the present case, Giphy supplying Facebook with an input, that will be present in all or virtually all cases that come before the CMA. And in reality, it is no different to an ordinary industrial case where a company seeks to purchase one or more of its suppliers or its customers. So although there has been criticism of Facebook, which I will deal with, it's important not to lose sight of the fact that the central legal issues raised by this appeal are general ones affecting all users of the system, and not, of course, just the decision maker. Now, these central points of principle obviously require considerable care and attention. And speaking for myself as someone who has practiced merger control law for more than 25 years, including 10 years within an international law firm, the issues raised by this appeal are of fundamental legal and practical importance. Now, the points I opened with yesterday, of course, in a sense, were forensic points. But what I was trying to convey to the court, I hope in a way that was helpful, was that the issues of principle raised by the tribunal's ruling are among the most important issues affecting stakeholders in this sphere. The scope of the CMA's powers in respect of preemptive action under Section 72, that is a novel and fundamentally important issue to get right, and it will have profound ramifications for the practice of merger control law and international M&A activity. And these issues, as has been adverted to, they have never been raised previously at the appellate level until now, and they were only raised at the level of the Court of Justice of the European Union very recently in the Ernst & Young case. And these, in my respectful submission, are important and difficult questions. Now, the central point is the tribunal has set out at 124, and I fully accept it must be read, first of all, in its totality, and second, in the context of the rest of the judgment. I don't seek to engage in some sort of three-card trick based on the sentence in 124. But it has set out for the first time, and without reference to any clear authority, a new test that the CMA's interim powers in respect of preventing preemptive action are not limited to safeguarding the power to impose a final remedy or protecting its investigation process, but also comprise a wider power to prevent action that has the potential to affect the competitive structure of the market. And that is the central issue in this appeal. Now, what I want to do in the rest of my reply submissions is to pick up on three points of principle going to that central issue, and then a handful of what I would call bittier points, which have arisen over the course of the last day and a half. And I will pick up briefly on some of the grounds Mr. Dimitri dealt with as well. Now, the first point of principle is we do say fair and square. The tribunal's interpretation of section 72.2 and subsection 8 is wrong in principle. So the court has my point that they define preemptive action not just in terms of an impact on remedial action, but on a wider basis comprising an impact on the structure of competition. So in my submission, it is obvious from the way that is put that preemptive action is broader than final remedies and allows some regulation of the competitive structure of the market during the interim period. And although it is not set out expressly in 124, it must at least be implicit in that the tribunal also thinks the words action which might prejudice the reference are not limited to protecting its ability to, the ability of the CMA to investigate during phase 2, which is my document destruction example. Now, our primary position is that this formulation involves an error of law. First, there is the narrow interpretive point, which is the wording prejudice the reference. It cannot possibly mean action that has the potential to affect the competitive structure of the market during the CMA's investigation. And if Parliament intended the first limb of section 72, subsection 8, to say that, it would have said so in the clearest possible terms. And Mr. Dimitri, of course, turns it the other way around and say, well, if they had intended to limit this to the process of investigation, they would have said that as well. But in my submission...
Well, that's what you said to us yesterday. You said, looking at the transcript, that you said the wording of the first limb really is very precise. It is, quote, impede the conduct of the reference concern, close quote.
The phase 2 reference, yes.
But that isn't the wording.
Well, it is prejudice the phase 2 reference. That is the correct wording.
Yes, but you said that it really is very precise. It is impede the conduct of the reference.
Well, perhaps that's
neither the word impede nor conduct appear in it.
And we had a debate about that. My lord actually put to you, well, that might be right if it said impede, but it doesn't. It says prejudice.
Well,
it doesn't refer to conduct either.
Well, if I was giving the impression that was a quotation from the statute, of course that's wrong. I wasn't saying that.
You said it was very precise.
But the point I was focusing on is the reference means the phase 2 reference. What I mean by precise, that it is focused purely on that second interim period. And the suggestion that narrow temporal focus becomes a sort of Trojan horse of cantilever for regulation of the competitive structure of the market generally, one in my submission cannot excavate that from the first limb. And I mean, the interpretive point I make is that, I mean, in a way, if these rather specific words, and I, of course I accept what your lordship says, if they actually mean protect the competitive structure of the market, that is a quantum leap in terms of statutory interpretation, whereas my interpretation in my submission fits more naturally with the structure of section 72.8 and indeed the rest of the legislation. So that's the interpretive point. I mean, there's a clear difference between the parties.
I mean, speaking for myself, I think the point you have to answer is the second part, limb 2, because limb 2 does use the word impede and says impede the taking of any action under this part which may be justified by the CMA's decisions. And Mr. Dimitriou has shown us, by reference to section 35.3, I think, and schedule 8, that the CMA's decisions on the reference can involve a very wide-ranging attack on things that are going on in the market. And the example she gives, which I think is a very clear example, is, for example, Facebook deciding not to continue to develop its sticker library because it has acquired Giphy, and that is something they didn't know about until very late on, and that's why the requirement, the proper meaning of impede the taking of any action which may be justified by the CMA's decisions is broader than just divestiture.
Well, I will come to that. I think technically that's more of a ground 2 point.
Well, it's
whichever
quite
ground.
important on the meaning of this section, because on the meaning of this section, you say it has to be construed as having 2 very precise limbs, and you say the second limb doesn't include anything to do with the structure of competition in the market, because all they can do, the worst they can do, is divest. And that's not really the case. And if that's not the case, then the tribunal's quite careful reasoning in paragraphs 20 and 21, and then in 1, 2, 4, is if not, I mean, the words they use may not be precisely one way or another, but we do see that the words they use taken, grounded in the guidance, grounded in the statute in different places, and you have to deal with that, I think.
Well, Lord, I will. I'm going to take this in stages if I may, but
Of course.
I will do that. So the first point is an interpretive point. You've got the difference between us.
Yeah.
The core conforming view. Second, on the legislative materials, to save time, what I've done is put these onto a page, which I will hand up, rather than reading them out.
An electronic page, I hope.
Well, Lord, this will be emailed to your Lordship.
So this is the second point of principle, is it?
Oh, yes.
Two pages.
2 pages.
I'm discounting the header. I tried to get in 1 page, but there was a risk then it would be unmoored from this case
Right.
and could crop up anywhere. So I'm not going to go through these one by one. We've underlined the parts of interest. What we say is what one sees consistently is a focus on the questions of integration and on remedies. The third point is that other provisions of the Enterprise Act support our submission. The Tribunal's formulation is wrong. If we can first go to section 81 of the Enterprise Act, my lords. It's in volume 2 of the authorities. Tab 21, page 1201. So this is dealing with interim undertakings in phase 2. And so your Lordships will see from subsection 1, this is dealing with the case where there's been a phase 2 reference, but it hasn't been determined. And then 2, it says, again, for purposes of preventing preemptive action and so on. And then in paragraph 10, you see the same definition of preemptive action as in 72. And if your lordships can keep your finger there, and then skip forward to tab 30, at 1644. Section 80 and Section 81. So these are the explanatory notes to these amendments. So the section allows the CC, as it then was, make an order to prevent the parties to emerge from taking any action that might prejudice the eventual outcome of the merger reference.
Sorry, where are you reading from, Mr.?
My lord, it's 234 at the top of 1644. And tab 30. So these are the explanatory notes.
Yes.
To the 2002 Act.
Right.
So eventual outcome of the merger reference. So the CMA's interim powers at phase 2 are limited to preventing conduct which could prejudice the eventual outcome of the merger reference. So we say again, this is about remedies. And given that the definition of preemptive action in sections 80 and 72 is the same, the legislature gave no indication that the CMA's powers at phase 1, which is by definition less detailed than phase 2, were more extensive than those available at phase 2. The second point of the legislation comes from section 77.2, again of the 2002 Act. Lord, it's 1198 of electronic bond, tab, same tab, 1198. And it's subsection 2, my lords. It says, no relevant person shall work the Senate CMA, complete any outstanding matters in connection with any arrangement which have resulted in the enterprises ceasing to be distinct enterprises. We say, again, this is integration. B, make further arrangements in consequence of that result, other than arrangements which reverse that result. So further information, further arrangements to effect integration. And then C, transfer the ownership and control of any enterprises to which the reference relates. So in phase 2, no sale or transfer of the relevant business activities to which the reference relates. And then 3, the question of consent and assistance in those activities. Now, enterprise is defined in section 1291 as the activities or part of the activities of a business. So 2 points. First, when seen in context, again, it is clear the CMA should or is concerned with integration. And second, the provision in subparagraph C, providing that the relevant enterprises to which the reference relates should not be sold or transferred, provides additional support for what prejudice to the reference could mean. So it means no further integration or disposing of the relevant enterprises to which the reference might relate. So in particular, limb C of subparagraph 2 relates only to the non-disposal of the relevant business activities to which the reference relates, and not more generally. And in this case, we say that was obviously gift-related activities, and not everything else remaining within the IO. And certainly what one does not see in section 77, which is dealing with completed mergers in phase 2, is a requirement that the competitive structure of the market must be preserved beyond this, or beyond these specific requirements. And we say this informs the limits of an IO under section 72 as well. The fourth point, we say the tribunal's interpretation would be inconsistent, first of all, with the presumption of legality of mergers, and I took the court to paragraph 277 of the CK Telecoms judgment of the European courts. We haven't had a response to that, so I assume at least the point made there is common ground. And second, would be contrary to the statutory requirement on the CMA to promote competition under section 25(3) of the 2013 Act. Fifth, another point which was not responded to, if section 72(2) is interpreted in the manner the tribunal has indicated, it would trespass on the jurisdiction of other parts of the competition legislative regime, notably Part 4 of the 2002 Act on Market Obligations and Section 18 on abuse of dominance. And I relied on the Ernst & Young case by analogy for that purpose. One further point in relation to Ernst & Young. Obviously, we're talking about a CMA decision in this appeal from 2020. Therefore, that fell within the Brexit transitional period. And one of the main points made by the Court of Justice is that if you expand the scope of interim measures under merger control law, you correspondingly reduce the jurisdiction of competition law in respect of agreements and abuse of dominance. And Articles 101 and 102. Now, during the Brexit transitional period, of course, 101 and 102 were fully applicable in this jurisdiction. So, in fact, the comment made, I think it was at paragraph 50 of Ernst & Young, in relation to an improper reduction of the scope of Articles 101 and 102, is bang on point when it comes to this case, certainly during 2020.
Why does it reduce the jurisdiction? Why aren't they concurrent jurisdictions?
Well, it certainly displaces it for that period. I mean, if there is an interim freeze on the taking of action for that period of 12 months, or however long it is, then it would be difficult to see what would be the point. But let me put another way, my lord. Let's suppose under Article 102, cutting off supplies to somebody was not an abuse of dominance, whereas by contrast, on Mr. Michu's interpretation, as an interim measure in a merger case, you'd be perfectly entitled to freeze that supply relationship and subject it to a non-termination provision for that duration. So that's a clear example where there would be a direct clash between these two jurisdictions. So under the legislation which we say should apply abuse of dominance, on my hypothesis this conduct would be legal, and yet it would, at least for an interim period, be prohibited under the interim measures legislation for merger control. So there is a clear clash of jurisdiction. What the court says in paragraph 50 of Ernst & Young is you shouldn't have interim measures, merger control legislation, encroaching on the jurisdiction of Articles 101 and 102. Not only do they coexist, but there is a specific jurisdiction for dealing with unilateral conduct and agreements which are not directly connected to the merger. So the point made in relation to Articles 102 and 101 in relation to displacement, certainly for 2020, have direct application in this case. The final point, again, is one which was barely dealt with, which is the C. France case. And you see this coming up again and again in the guidance in the CMA's submissions. And the CMA has effectively, in my submission, abandoned reliance on this case. So Mr. Michu said yesterday, and I quote, "We only cited C. France for the very obvious proposition that this merger control is ex-ante merger control, regulatory control, nothing more than that. We certainly weren't reading it into the ratio, some principles. But with respect, that isn't right. If you go to their skeleton at 46D, C. France is in fact the only case the CMA cites as supporting its interpretation of paragraph 124. So in my submission, that has been effectively put to one side, so that the CMA is in the difficult position of not having a single authority said to support its position. So that is our primary submission, that the tribunal's interpretation of 124 is simply wrong for a whole series of reasons. Now, my alternative submission is that if, contrary to my first point, the CMA's powers under the first limb of 72.8 do extend beyond its final remedial powers, then the CAT's formulation of 124, as I think is now common ground, remains too broad or requires clarification or refinement. Now, the CMA says at paragraph 37 of its skeleton, I quote, CMA has always recognized that any preemptive action which it seeks to prevent or prohibit by way of an IEO must be connected with and arise from the merger transaction in question. So on this basis, paragraph 124 at least is incomplete, or maybe even misdescribes the CMA's position, because it should at the very least have included a reference to a causal link. But that is still rather vague, because in particular Mr. Michu says something arising in connection with the merger would be enough, and that is even looser than causation. Now, if the words caused by the merger are added to 124, in my submission that is still problematic. Mr. Michu presented this as some great concession or evidence of reasonableness on the CMA's part, but it isn't, because the CMA's action, as a matter of law, can only involve that which is specifically related to the merger. That is a mandatory requirement. It is not a concession to be offered. But the main problem with this formulation, simply by adding causation to 124, is that it simply begs the question. It's all very well saying something must be in connection with or caused by a merger, but the key legal issue is, where does one draw the line? And the problem with 124 is that no line is drawn, at least reading that in isolation, except it is not correct. And we say in the Ernst & Young case that action, for example, taken to terminate an agreement, which was a direct consequence of the merger agreement, in that case, did not fall within the scope of interim measures powers for the purpose of EU merger control, and yet on the CMA's interpretation, even with this qualification, it would, and so would any other action affecting the competitive structure of the market arising in connection with the merger. So we suggest that even by adding causation or the vaguer words in connection with the merger, that still goes too far. See Ernst & Young.
The problem with that, Ernst & Young wasn't dealing with interim measures there, was it?
Well, Article 7 is the interim measures power or prohibition of European merger control. It puts a prohibition on the putting into effect of the merger, and it is a breach. It is an interim measure which is imposed on the merging parties. And the question in that case was, if you have other agreements of conduct which arise in connection with the merger, are they captured within the four walls of that interim measures power? And the Court of Justice took a narrow view for the reasons I've outlined. It said, well, we can see in the Ernst & Young case, the termination of the cooperation agreement within KPMG was a requirement of the merger agreement, and it was in fact terminated. It had a dramatic effect on the market because it led to customers actually switching. That omelette could not be unscrambled. It was clear it was irreversible. There was an actual impact on the market structure. The court says, well, the jurisdiction of interim measures, for a series of reasons, including the coexistence of different jurisdictions under the competition legislation, simply does not capture the termination of the cooperation agreement, even if it arises in connection with the merger. And I mean, in this case, there was no question. It was causally related to the merger. There was no question about that. It was a requirement of the merger agreement, the termination of the cooperation agreement. So the court, in a sense that the court has a choice. The Court of Justice has said, we read the jurisdiction for interim measures and merger control as being quite narrow, as really involving the direct integration steps of implementing the merger. By contrast, the tribunal and the CMA say, well, no. It is much, much broader. And essentially, anything done in connection with the merger that has an impact on the structure of competition in the markets that CMA is looking at can be prohibited as an interim measure, even if as a final remedy, CMA would be unwilling or unable to do anything about that. So that there is a stark choice for the court as to whether my interpretation is correct or the CMA's and tribunal's interpretation. And the problem, if I may say so, with 124, and I accept it must be read with 21 and 22 in mind, and 127, I accept all of that, is it simply says in bald terms the competitive structure of the market. And it is completely unclear, including, I would suggest, even if one reads 21 and 22, where the tribunal is drawing the line. And the European Court in Ernst & Young has drawn a very clear line for reasons of principle. The CMA and tribunal have a much, much broader line, which seems to involve capturing all kinds of conduct on an interim basis, even if, as a final merger remedy, nothing could or would be done about that.
Well, you keep on saying that, Mr. O'Donoghue, but I did put to you very early on in your reply submissions the request to deal with the submission that it's not a very narrow power in the CMA in the phase 2 review. And I think you do need to deal with that, because if Mr. Dimitriou were right and you were wrong about that, then even if your construction technically was to be preferred and it should be pinned down to the steps that can be taken under remedies, that would be much broader and therefore give rise to much broader interim orders.
Oh yes, I won't run away from that point.
Thank you.
But can we go back to paragraph 43 of the CMA skeleton? It's in core bundle tab 4, page 67.
Paragraph 47.
43, my lord.
42.
So they say so the third line, definition of preemptive action encompasses both action, so remedial powers.
Sorry, I must have got the wrong document.
So CMA skeleton, my lord, tab 4 of the core bundle.
Paragraph 42 of the CMA skeleton.
43.
Ah, 43. Sorry. Yeah, got it. Yeah.
So they say, third line, the first part is remedial powers, which I'll come to at the conclusion of the investigation. And then you see the underline and action which the merging parties may take in connection with or as a result of the merger that alters the competitive structure, but which may prove irremediable at the conclusion of the investigation. So that's why I say there's a stark choice. They say doesn't depend on remedies. There is essentially a freestanding power within section 72, subsection 8, which, regardless of remedies, allows the CMA on a purely interim basis to do something to regulate the market, even if on a final basis it would be unable
Well,
to
you're
do anything.
not really appealing their submission. You're appealing paragraph 124.
Well, but this is their gloss on 124. They say this is what we told the CAT. So when you read 124, this is what it really means. I mean, it's the same point. So that is why I say that there is actually a very clear difference of principle between us. That there's a hard-edged point the court, in my submission, needs to resolve. So what should 124 say by way of clarification? We say there are two possibilities. First was the point the Master of the Rolls adverted to yesterday, which we see in spades in the statutory materials I've handed up, which is the concept of integration. So if we go back to 124, we would say action that has the potential to affect the competitive structure of the market during the CMA's investigation here's the additional words, caused by integration or possible integration of the merger parties.
So where are you reading from?
Well, my lord, this is the wording we would propose by way of clarification.
Right.
So in 124, you see the phrase affect the competitive structure of the market during the CMA's investigation.
Yeah.
We would propose as a first possibility, the court add the words caused by integration, comma, or possible integration, comma, of the merger parties.
Of the merger.
Parties. So it is linking it to the direct focus or the incremental change of the merger, which is the addition of the target business or the integration of the two companies. So that's the first possibility. A second possibility would be to link it to the definition of enterprise under the Act. If we go back,
I thought I'm sorry to be difficult, but I thought you submitted that it wouldn't be good enough just to put in causation. You said earlier we say causation is one thing, but that wouldn't be good enough. The whole thing is wrong.
That is necessary but not sufficient. What also needs to be added,
Right.
well, the integration effectively builds in causation, because the change in the market caused by the transaction is the integration. So it's a composite point.
Referring to integration adds nothing more than referring to the merger, does it? Merger is the integration.
Well, it is the steps of integrating and further integrating in a simple example, the two companies.
But that's a merger.
Well, it is capturing those activities and nothing else.
Lord Master Roll's point, I think, I may say, is that all you're adding here is causation, rather than connection.
Well, I am, but in my submission, it is more precise because it is anchored only in integration and not some effect that arises in connection with the merger more generally. I mean, it's the Ernst & Young point.
I mean, why is that different from what? I mean, I don't think we want to get into a drafting committee, but why is it different from what Mr. Dimitriou suggested, which is this includes action related to the merger that has the potential to affect during the course of the CMA's investigation the contested structure of the market or markets may be the subject of that investigation.
Well, it is the Ernst & Young point. I mean, her formulation would capture the termination of the cooperation agreement in that case. Mine would not. That is the clear difference.
So your formulation would do what?
Would not. So if in Ernst & Young, the act which was challenged was the termination of the cooperation agreement, which arose in connection with the merger agreement.
Right.
Her formulation captures that. Mine does not, because it is something which is essentially extraneous to the merger. It is not the direct
Just
putting
help
into
me.
effect.
Just answer because. I mean, just
Well,
so I understand, because I
well,
think you're losing me.
Well, it goes back to the jurisdictional point. So one of the main reasons that the Court of Justice said, what you should not be doing is including actions and agreements that arise generally in connection with the merger within the scope of intrameasures jurisdiction. Mm-hmm. The only thing the intrameasures jurisdiction is intended to capture is the direct putting into effect, the integration of the companies. Mm-hmm. The fact that there are other effects which are causally related to non-integration aspects of the merger, they are not within the jurisdiction of interim measures. So that is the clear difference between us.
I understand the E&Y point, but what I don't understand is why your formulation is different from hers in that respect, because surely the change is caused by the integration. As you said, the agreement that was terminated was caused by the integration.
Yes, and the court said that is not within interim measures jurisdiction.
No, you said that the agreement in Ernst & Young, that came to an end
Yes.
as a result of the merger, came to an end as a result of the merger.
Undoubtedly so.
And therefore your formulation, adding into the fourth sentence, caused by the integration or possible integration of the merger parties, would catch the Ernst & Young situation.
No, because it was not an act of direct integration. That's the point. It was an act of terminating.
No, but it was
a third-party
caused
agreement.
by the integration.
It was caused by the
The
integration.
act of terminating the other agreement was caused by the integration or possible integration of the merger.
Well, indirectly, yes.
Yes.
It arose in connection with the merger. It wasn't a contractual requirement.
No.
But Mr. Michi's formulation would capture any and all agreements of that kind. My formulation, at least in terms of intention, would not.
Okay. All right.
So that's one formulation. Now, the other formulation, which I actually take much more quickly, I hope, is based on Section 77 of the Act.
I mean, this is all new. Section 77 wasn't even mentioned in your skeleton. I can tell you it wasn't. I've taken the precaution of searching.
Well, Lord, I'm reacting to the phrase in connection with the merger.
Well,
I'm trying.
probably doesn't matter, but
I'm trying to help the
Just
court.
mentioning
Well, Lord, that's fair. I accept that. But it's really to respond to your lordship's point.
Yeah.
If 124 is to be clarified, what can usefully be done, and where can we get inspiration from? So I'm trying to be
yeah.
as helpful as I can. So we go back to tab 21 of the authorities.
We're looking at 77.
Oh, yes. So this is restrictions on certain dealings in the case of completed mergers. And if the court can look at subsection 2, so it talks about complete any outstanding matters connected with any arrangements which have resulted in the enterprises concerned ceasing to be distinct. And then you see examples in B and C, transfer of ownership and control of any enterprises. And then subsection 3, reference to the activities.
To cut to the chase, you're going to advocate using the formulation there.
Yes.
But that formulation is about the reference, when a reference has been made, not about the situation before a reference has been made, when the CMA knows nothing.
And it's specifically in the case where there are no undertakings given under Section 80 or an order under Section 72. So how you can use this as an interpretation of Section 72 is
Well,
I just don't see it.
well, my lord, in my submission, there has to be some basic consistency between the interim measures powers in phase 1 and phase 2.
Because as my lord just put to you, it's dealing with it's the apples and oranges point again, or apples and pears, or whatever. This is dealing with a situation where there hasn't been a Section 72 interim IEO at all, and there's now a reference. So there's a phase 2 reference, and this is dealing with what can or can't be done at that stage.
Well, I accept that, but one would logically have thought that in a case where in phase 2, for whatever reason, an interim measure is not in place, at that stage the CMA perceives, well, it's jolly important that we have interim measures now in phase 2. We've sort of missed a trick. It would be quite strange in my submission that if the powers in that situation, in phase 2, which is the critical phase, were much more attenuated than at phase 1. There must be some basic consistency. But, I mean, in a sense, nothing turns in that. The point I'm focusing on is that there's a statutory definition of enterprise in section 12991. It is the activities or part of the activities of a business. So if we go back to 124, so everything would stay as it was. And we'd add a new sentence after prejudice phase 2 reference saying this means preserving the activities to which a reference would relate.
This means preserving the activities.
The activities. So linked to the definition of enterprises by cross-reference to
to
section.
which the reference will relate. And would become the 5th sentence in section 20,
Lord, yes.
para 124.
Now, the possibility which Mr. Michu has advocated as a third or first possibility is, well, you add in something to do with the markets. Now, it would be quite strange in my submission, bearing in mind what I said yesterday, if I were over the moon about that. I mean, in my submission, that is an inherently problematic and defective formulation. Because the one thing, but the only thing the CMA and the applicants agree on is that in phase 1, in fact in most of phase 2, it is difficult, if not impossible, to reach a landing point on the definition of the markets and competitive effects. So in my submission of the 3 alternatives you've been presented with, that has the least to commend it, because it is impossible to apply in any useful way on an interim basis when information may be limited.
Right.
Now, one final point to pick up on an exchange with Lord Justice Phillips yesterday. It's interim versus final powers. And your Lordship put to me yesterday that in a civil litigation context, interim orders are often wider than final orders. And your Lordship gave the example of an Anton pillar order. And your Lordship said, I quote, "There's no final remedy in Anton pillar relief. That is an interim remedy which is designed to ensure that the ultimate remedy of a money judgment is properly reached." And with respect, the last words, the final words, that is precisely the point. Because even if an interim remedy is wider than a final one in practice, it is still aimed at ensuring the final remedy can be imposed, if appropriate, and not for some extraneous or other purpose. And by contrast, it is clear from paragraph 43 of the CMA skeleton, by the use of the underline "and", that they envisage a possibility whereby you can have preemptive action which is just linked to remedial action, and then there is a standalone power to impose interim measures on a temporary basis, even if they are completely unmoored from any final ruling. So that is the clear difference between us. Now, your Lordship also mentioned the example of a freezing order over property, whose ownership, for example, might be unclear at the interim stage. But again, same point, the aim of making such an order is to preserve the court's ability to make a final order. And with respect...
The ability of the court undoubtedly retains the ability to make the order. It's to maintain the effectiveness of the final order.
Well, your Lordship, if I say so respectfully, put it very well yesterday. So page 73, lines 15 to 18, your Lordship said, and I quote, "These are orders which are designed to preserve the position so that the full powers at the end of the day will be available." And we would be very happy with that as a description of the CMA's interim measures powers. The CMA in paragraph 43 of its skeleton, which replicates 124, wants something far more extravagant, which is unmoored from the issue of final remedies completely. In other words, we submit, the IO and the CMA, they're going further than the statutory power. Well, just to wrap up very quickly on the other 3 grounds, which I can take much more quickly.
Yes.
On ground 2,
I mean, you're not still not answering
So
my
we answer the question.
my question. I mean, you can say that's another ground if you like, but we just need an answer before 1 o'clock, if possible.
well, which question?
The question about the breadth of the remedies available.
Yeah, well that's the one
Schedule 8.
I'm coming to now.
Yeah.
Right.
So, Mr. Dimitri effectively made that point. Now, the point she has not dealt with, and which she, in a way, made a virtue of, she said, well, we can't fetter our discretion by saying we would never allow the acquirer to divest some of its assets instead of or as well as those of the target. But I made the point yesterday, which has not been responded to, that is a concession to the merger parties on the basis that all else equal, if the two remedies do the job, CMA, as a matter of discretion, is agnostic, provided that outcome is achieved. Now, that's all well and good, but what we're dealing with here is that they want to rely on that concession as a basis for imposing a detriment on Facebook at this stage. And that simply doesn't follow. I mean, to put it another way, we would be very happy to give an undertaking in open court, hypothetically, say, well, we have no interest at any stage in offering you up some of our assets as a divestiture. If you want to conduct a divestiture, you have full permission to divest any and all of Giphy. But we don't want that concession. So that's why we say they cannot at this stage rely on something which is really for our benefit at the end of the process to say, well, here's this extraordinary detriment on an interim basis.
But I think you're missing the point, really. I mean, I see the way you put it, but the point is that Facebook might acquire Giphy and then ditch its own development of stickers and GIFs. And at the end of the process, say, I'll accept divestiture but nothing else. And the market looked at objectively at the end of the process, you won't have got Giphy, but you also won't have your own marketability to compete with Giphy. So they need more remedies than just divestiture in that extreme situation. Of course.
Well, that is exactly back to my jurisdictional point, because it may well be an abuse of dominance for Facebook to discontinue its sticker store. But Facebook is self-evidently not acquiring its own sticker store. It already has that, and it will have it going forward. So in my submission, even as a matter of causation and merger specificity, to suggest that at the end of a process involving the assessment of the acquisition by Facebook of Giphy, that Facebook divesting a sticker store, which it has always owned.
But it's hardly abuse of a dominant position to put yourself in a worse position in the market.
Well, that's why it's even more upside down. It makes even less sense. I mean, my point, again, it's a jurisdictional point. If for whatever reason Facebook became disinterested in a sticker store, that may be a stupid thing to do, but it's very hard to see how in the face of it, getting a machine gun out your own foot would be an abuse.
You say it's ridiculous because that's our problem.
Well, I mean, that's one way of looking at it. But the more substantive point is that can only be assessed as a potential abuse of dominance because it's a purely unilateral act. And it goes back to Ernst & Young because to say, well, this arises in connection with the merger, therefore we have interim jurisdiction over this, even if as a final remedy we would not.
See,
that is wrong in principle.
Just take my Lord's example for a moment of you acquire Giphy and you wound down, or as my Lord said, ditched your own development of stickers. So you don't have any competitive sticker business, if I put it that way, or GIF business. Why couldn't an enforcement order against your clients under Schedule 8, Paragraph 10, require you to, as it were, reconstitute your sticker business, because it can make an order requiring you to supply goods or services or do anything which the relevant authority considers appropriate to facilitate the provision of goods or services. So the CMA could say to you, look, as a result of what you've been up to during the course of our investigations, you've actually prevented yourselves from competing in the market. We're not having that. Here's an enforcement order under Paragraph 10 of Schedule 8.
Well, the simple answer is that is not a merger-specific effect. Facebook has always owned its sticker store. What it does in relation to that sticker store, even if it arises contemporaneously with a merger review, is simply a matter.
That's not. I mean, what's the answer? I mean, it goes back to my Lord's question to you at the beginning of your submissions. With
But
respect,
it's a
which
causation
you've yet
point.
to answer.
We're not.
I put to Mr. Demetriou yesterday paragraph 12 of Schedule 8, which talks about an order prohibiting or restricting the acquisition by a person of the whole or part of the undertaking or assets of another person's business, and that clearly is wide enough to encompass acquisition of some other business by Facebook.
With respect, one cannot read the remedies in isolation. One sees from section 44, the only powers of the CMA are to remedy the substantial lessening of competition. That is a merger-specific assessment. The merger-specific assessment is the addition of Giffey. If contemporaneously or
Your
separately...
problem, Mr. O'Donoghue, with that is section 35(3), which says that it can also decide the additional questions, whether action should be taken for the purpose of remedying, mitigating, or preventing the substantial lessening of competition concerned, or any adverse effect which has resulted from the substantial lessening of competition.
Yes.
Now, that includes you giving up your sticker business.
Well, no,
Take my example.
in my submission, no.
How?
Because it
How
is
now?
not a merger-specific effect.
But it is a substantial lessening of competition.
No, because the substantial lessening of competition has to do with the change caused by Giffey.
No, which has resulted from the substantial lessening of competition.
It's
Not
focusing
the
on
merger.
specifically on the substantial lessening of competition itself, but on adverse effects resulting from that, which clearly must be wide enough to encompass my Lord's example, mustn't it?
Well, the meaning of merger specificity is a legal question, and my submission is that what one cannot do and should not do is retrofit from the remedial powers, which are expressed in broad terms, I accept that, and say, well, therefore, anything which can be shoehorned into those broad
Right.
powers is a merger-specific effect.
So you say you cannot, I mean, to put it clearly, you cannot retrofit from the broad
And general powers in respect of remedies to deem something which is not a merger-specific effect to be a merger-specific effect, just because in the abstract you could require a contract of that kind to be concluded. I mean, it's a nonsense.
That rather unhinges your argument from its core tenet, doesn't it? Which is it's all to do with what the remedy can be at the end of the day.
Well, no. I mean, of course, the remedial powers are general, and we've seen those. They say what they say. But in principle, there can be two types of remedies. One is a divestiture. The court has my point that it's a target-side divestiture, because that's the merger-specific effect. And the other is a behavioral remedy. Now, within those two buckets, then there can be a series of creative measures. But in my submission, it is an error of principle to say that just because within lawful merger remedies one could do creative things, therefore as a matter of interim measures powers, the CMA has the power to regulate all kinds of things on an interim basis, even if it could do nothing about them on a final basis.
So there's powers to do creative things, but you can't take steps to ensure that you can do the creative things.
Well, my Lord, no, I would put it slightly differently. There are essentially two candidates for types of remedies. There's a divestiture of the target, and there are behavioural remedies. And they both have to be related to a merger-specific effect. And again, Facebook is not buying its own sticker store. That is not a merger-specific effect, and it is not an effect which could be the subject of a final merger remedy. It could be the subject, and indeed could only be the subject, of perhaps a prohibition on abuse of dominance, but perhaps a market investigation under Part 4. But it does go back to the jurisdictional point, which is, does the fact that the interim measures happen to coincide in time with other things which are happening in connection with the merger give the CMA the jurisdictional power to take, on an interim basis, actions which it could not take on a final basis? I mean, it does collapse into the same point. I mean, the defect, if I may say so, in Ms. Dimitri's formulation, is that it is gelatinous. On her definition, in broad terms, arises in connection with the merger, and could, in a loose sense, be said to be somehow causally related. That comes within the jurisdiction of interim measures, separately from the question of whether this could ever be remedied by way of a final remedy. And we say that is wrong. I mean, on the sticker store, of course, the other answer is it's all a bit theoretical, because in paragraph 5D of the derogations, as amended, all this is carved out anyway. And I understand your lordship is putting to me a hypothesis or a theoretical point to test the point, but that is one answer. But my answer is that things to do with the sticker store are not a merger-specific effect, and therefore could not be the subject of either interim or final remedial powers. And just because
it would be a merger-specific effect, because, I mean, it would be self-harm writ large for Facebook simply to ditch its own sticker business if it had not bought Giphy. So presumably it can only be because, and it could be, I mean, one could presumably seek evidence about that. You could have you could have disclosure, and you'd find a memorandum from Director 1 2 saying, I think we won't spend any more money on this, and in fact it's a bit of a waste of time. Now we've got Giphy. But
unless that is an abuse of dominance, it is not anti-competitive.
I mean, I've got the point, and I mean, just to say, I mean, you did, and a merger-specific effect seems to be a new phrase to me, but in paragraph 63 of your skeleton, you said the examples in 127 illustrate the breadth of the CMA's powers under 72.2, which stands in stark contrast, under the tribunal's interpretation, which stand in stark contrast to its more limited power to impose final remedies to address merger-specific effects. And what my lord and I have been putting to you is that they're not very limited.
In my submission, for the reasons I've outlined,
You've said that
they have to be.
They have to be because of Ernst & Young, really.
Well, otherwise it is a jurisdictional mess.
Is there anything in the, does the statute, the domestic statute, use the words merger-specific effect?
Well, no, I mean, that is essentially a paraphrase.
That's just a gloss.
Of the SLC. Well, my lord, if one looks at the CMA's substantive guidance...
So it's a gloss of the SLC. So
well,
merger-specific effect is substantial lessening of competition.
Yes, but the key point is that it has to be...
Well, how does address my lord's point about section 35(3)(a), or any adverse effect which has resulted from or may be expected to result from the substantial lessening of competition?
Well, if we go back to my integration point, it has to be something which directly involves the integration of the Giphy business.
I think we got the point.
I mean, it's interesting, just doing search in the authorities, merger-specific effects is riddled throughout in management in ICE.
Yes. I mean,
but not in our present way.
Well, no. Well, as I said, it's a mandatory requirement. It's not some big concession.
No, I mean, I'm just interested in terminology, actually.
And, my lord, in the CMA's substantive guidance on mergers, there are entire sections on merger-specific effects. So this is not something I've come up with on the hoof.
No.
But I mean, I'm sorry to keep doing this, but if we go back to Ernst & Young, to my lord the Chancellor's example, I mean, it is beyond question that KPMG Denmark effectively exiting the market and putting in its lot with Ernst & Young had a significant adverse actual effect on the market. And it is beyond question that when KPMG then retaliated and stole some of the customers of its former partner, that also had a profound effect on the market, perhaps a beneficial effect.
No, I mean, I think we get that, but I mean, we're not construing Article 7.
Well, my lord, certainly for 2020, that it is relevant because of the Article 101 point.
But we're not construing Article 7. It's a different regime. The European Union's competition regime is different.
And it's a regime that requires prior notification.
Yes.
Anyway, I think we've bottomed this out. I don't
Well,
want you to ignore
we have, but I mean,
rounds 3 and 4.
it does give rise to a very stark point, which is if this is indeed the interpretation of the domestic legislation, the CMA seems to have interim powers that no other merger authority in the world that I'm aware of has. And that would be a very striking thing. And that is why I say one would have expected to see in the statutory language of the explanatory materials the clearest possible unambiguous articulation of why this sort of Trojan horse has suddenly emerged. We don't see that, and there were of course significant changes in 2013. There are lots of explanatory materials. They did tighten up the interim measures powers in certain respects, but what you don't see in any shape or form is saying, by the way, we've also now realised that if you don't have interim powers that exceed anything you would wish to do by way of a final power and allow you to regulate the market in the interim on some sort of preventative basis, irrespective of the other competition laws, that is a jolly important thing. You don't see that anywhere. And that dramatic change in the competition landscape, you would expect to see that set out in some detail, to have been consulted upon in some detail. You'd expect to see a lot of consultation on, well, where does this leave Section 2 and Section 18, Part 4 on market investigations? Are we stepping on the toes of other parts of the legislation? You see none of that. I mean, this has essentially come out of the blue.
Well, it's come out of the blue, but it's been going on for 7 years out of the blue.
A number of years, my lord, yes.
Yeah.
It's relatively recent, I think.
Now it's for us to determine whether it should continue to go on.
My lord, yes. Well, I see the time. I can spend 5 minutes on ground 3
Yes, and 4.
and 4. So on ground 3, 3 points. So Mr. Dimitriou's main point as well, unless and until we had clarity as to primarily what paragraph 5D meant in terms of what was carved in and carved out, we were entitled to stick to the IO in its underogated form and not accept the track changes version you put forward. Now, the first point in relation to that is, well, if the litmus test is clarity, then multiple other provisions of the IO are, if anything, less clear, or at least subject to the same criticism. So the tribunal has my point, which hasn't been addressed. 4C talks about the markets affected by the transaction. Difficult, if not impossible, to define those until the end of phase 2. The court has my point, which again has not been responded to. The definition of key staff is extremely unclear. Positions of executive or managerial responsibility and or whose performance affects the viability of the business. Not clear what that means. I mean, if it's indispensable.
I mean, don't waste time repeating submissions you made yesterday.
Well, they haven't been responded to.
No.
That's the point. But well, the other point is, I mean, the fundamental premise of the IO and the regime is that it is based on self-assessment. And just to give you the reference, but paragraph 55 of Mr. Romney's statement, he says, and I quote, CMA expects parties to a merger who are subject to an IO to self-assess.
Yes.
And as we set out in our supplemental scale, I'll just give you the reference. It's 2nd of July, 11th of September 2020, supplemental 26407. When we went to the CMA on more than one occasion, it said, well, can you tell us what the IO means, whether there is a breach? They said, and I quote, it is for Facebook to ensure compliance with the IO. And in that context, 2 points. First of all, we've got the monitoring trustee and the whole separate manager. These are further protections whereby all this can be worked out with the supervisors. And second, of course, there is a bi-monthly reporting requirement. It is through that iterative process of Facebook, with the help of the monitoring trustee and whole separate manager, explaining exactly what has and what hasn't been done, what's in and what's out. That is how that is fleshed out. So there is an iterative process of self-assessment and compliance, whereby all this can be worked out with great precision. So it is simply not the case that the CMA would be in the dark. and it would be at least as well informed as it is in relation to multiple other provisions of the IO. Then on ground 4, 2 minutes, if I may. So this really is about the information and the point of principle. I'm not going to labour this point, but so the essential charge against us is, well, you told us nothing, cocked a snook, and so on. If I can just ask the court to type one document quickly, it's in the supplemental bundle, paragraph tab 13.
Page.
My Lord, it starts at 282. So this is Ms. Del Rosario, the compliance certification person until quite recently. You'll see the start of paragraph 16, application of paragraph 344 of the interim measures guidance. So Ms. Dimitri's main complaint was, well, we sent you our checklist of information and you cocked a snook. And with respect, that isn't right. We've explained in very considerable detail over these pages exactly what was the problem with this template and the rigid approach of the CMA, why for a company organized in the way that Facebook is, it was simply not workable. And we have never had a response to this important evidence, and the court will also see it is not evidence that the tribunal forms any view of at all. And in fact, it was uncontested. So it is not correct. And my lords, it is of course implausible that somebody who is seeking a derogation from something which is said to be restricting the company globally would apply for that derogation and then cock a snook at the person who was granting the derogation. That is inherently unlikely.
Well, I mean, Ms. Dimitri described it as getting on your high horse.
Well, my lord, we didn't. We've set out in
But I
consideration.
mean, the tribunal found that you did get on your high
Well,
horse.
yes, but they didn't consider this uncontested
Well,
evidence.
paragraph 159 of the tribunal's judgment is a finding of fact which is not the subject of an appeal.
115.
It's unsatisfactory in this case that Facebook has not sought to engage with the CMA, has not provided the CMA with information to ensure its carve-out requests are resolved so that it can submit unqualified compliance statement. The finding of fact which you have not sought to appeal. So why are you referring us to a witness and criticising the tribunal?
That is on a different point. That has got to do with the certification of the compliance.
Well, we can no
which
doubt
was
go
qualified.
back through these, Mr. O'Donoghue, but you know very well that the tribunal has found in a number of places your clients failed to engage at all with the CMA, and that was the problem.
Well, there isn't a single reference to this important evidence.
Sorry, there isn't a single
Reference to this important evidence, I've shown. It is not evaluated.
So why didn't you seek to say something about that in your...
Well, we do. That is ground 4.
Well, I thought ground floor. I mean, I may be misunderstanding it. I will take a little time. I'm not going to stop you answering the court's questions, Mr. O'Donoghue. My understanding of ground 4 is that the tribunal was wrong to characterize the decision as a mere decision to request further information. Actually, it was a decision to maintain the IEO and to refuse the derogations which Facebook had sought. And had it characterized the decision properly, it would have found that the proportionality standard applied and that the CMA's information requests were disproportionate. Now, Ms. Dimitri's answer to that is see paragraph 20 sub 3 in BAA, which says that it's a rationality standard when asking for information. But even assuming that it is not to do with asking for information, but is, as you say, a refusal of the derogations, and you apply a proportionality standard, that comes to the same thing, because of what Mr. Justice Sales said. Now, how does that get us into Mr. Del Rosario's evidence?
Well, can we go back to our skeleton argument?
Yeah.
It's core 3, page 51.
Mm-hmm.
So at 81, Your Lordship is exactly right. We say that the decision properly characterised also relates to the decision to continue the IO in its undererogated form for each and every day continue to apply. That's paragraph 81. And we have not had a response to paragraph 81 from the CMA. So that is important. And if you then see at the end of paragraph 79, the top of the page, we refer to the passages in Ms. Del Rosario's evidence, which I've just shown the court.
Yeah.
But my understanding of ground 4, perhaps I'm misunderstanding, but I think you told us yesterday it was a short points of principle, is you say that the tribunal applied the wrong legal test. You say that they should have engaged in disproportionality or proportionality assessment rather than a rationality assessment. And you say, as your point about Mr. Del Rosario, as I understand it, is predicated upon what the position would have been if they'd engaged in a proportionality assessment. Is that?
Well, at the start of 79 of the skeleton, you will see that they failed to address essentially Ms. Del Rosario.
It's the same point. No, because this is to do with whether the issue for the tribunal at this stage was whether the CMA had acted rationally, as the tribunal found, or whether what it had done was disproportionate, as you were alleging. So it's a question of law, isn't it?
But, my Lord, in my submission, it's a mixed question. I mean, we put in uncontested evidence. It has not been dealt with in any shape or form.
Mm-hmm.
Well, okay, I think we've got to go back to the decision and your skeleton, which we will do, Mr. Ridley, you may be assured. Is there anything else that we should cover?
Oh, no, I see the time. Well, there was one question Your Lordship asked yesterday about other merger reviews being conducted.
Yes.
So, my Lord, the position is, first of all, no mandatory notifications were triggered anywhere in the world.
No
mandatory notifications
Yeah.
were triggered anywhere in the world.
Oh, yes.
Second, there have been 2 voluntary notifications in Australia and the United States.
Yes.
Now, the investigation in Australia is effectively seems to have fallen into abeyance. We've heard nothing from them since July of last year. They have not an IO or anything like it. In fact, they've imposed no interim measures at all, and they, unlike the CMA, would have to go to court to apply and justify interim measures. Likewise, the United States, as I said, the mandatory thresholds under the Hart-Scott-Rodino Act at a federal level were not satisfied. I hesitate to use the word, but the Federal Trade Commission, relying on ex post powers, has made a number of requests in relation to the merger, and again, they have not saw fit to impose any interim measures. They too would have to go to court to impose such interim measures. And finally, as I think I indicated yesterday, there is
something in Austria.
There's been a jurisdictional question raised, I think in the last month, in Austria, and there is still a tete-a-tete in relation to that.
I thought there were some proceedings in the USA, proceedings as opposed to dealings with the competition authority.
Well, I think the opening of the request, I think it's called a civil investigative demand. I think in a technical sense, yes, that does require them to open some proceeding, but it is not a mandatory merger review, I think.
Right.
So the only authority.
None of it's relevant for what we have to decide.
No, I mean, well, except in the sense that none of these people saw fit in their jurisdictions to impose anything like the restrictions we've been subject to.
No, Mr. Mitchell.
May I just detain you for a few seconds to give you some references which emerged from Mr.
Yes.
O'Donoghue's reply? I'll be very, very brief. So, first, to be fair to Mr. O'Donoghue, the note that he handed up doesn't purport to be a comprehensive or even-handed
No.
exposition. So,
Clearly
but
not.
there is, when it comes to the explanatory notes, could I just ask you, because I don't think you've been taken to this, also to look when you're going back to it at paragraph 236, which is at 1648 of the authorities. It may be helpful to go back to Mr. Romney's statement because he sets it all out at paragraphs 39 to 43. Is supplemental bundle page 226. So that's the point about the explanatory notes. Just two further points. Mr. O'Donoghue purported almost to said that Facebook would be prepared to give some kind of undertaking to the court that it would only accept a divestment of Giphy and not be interested in any other remedy. And could I just ask you, I'm not going to read it aloud because it's confidential, but could I ask you to read in that regard paragraph 51C of our skeleton argument, which is page 74 of the core bundle, which is highly relevant to that submission, which we say on its own account is a misleading submission in the light of what we've said at that paragraph. I'm not going to read it out, as I say. And the third point is that Ms. Del Rosario's witness evidence was, of course, reply evidence. Of course, there wasn't a further reply from the CMA, but it was considered by the tribunal, and you'll see that referred to at paragraph 136 of the tribunal judgment, which is page 145. And the conclusion you've seen is around paragraph 155 of the tribunal's judgment.
159.
Sorry, 136 it was considered, and I think the conclusion is at the end of that passage. It's 155, I think.
Yeah.
Yes, it is.
Thank you very much.
Lord, I don't like the word misleading being used, if I can respond.
I didn't take it as misleading at all, Mr. O'Donoghue. I understood exactly what you were
Lord,
doing. Which is setting...
I was putting a hypothetical
You were-
to you.
You were setting out... I'm sorry, I think... I'm talking about your document. Is that
Oh, my Lord. No. This is the paragraph 51 of their skeleton, which Mr. Beecher said I was misleading in relation to.
I didn't understand you to be formally offering an undertaking. You were positing an example.
Well, it was for further discussion, but there is a further point which, in a way, blows it out of the water. I mean, at the very outset of this case, Facebook committed in a public forum for 5 years that it would maintain all of the pre-existing access and procurements in relation to gifts and stickers that it had in place.
Mr. O'Donoghue, you needn't think that we are going to think that either side has behaved improperly in this case. It's not that kind of news.
Well, I know that, but I don't like the word misleading being used.
Well, I'm
My
sure...
Lord, I'm happy to retract that. I didn't mean misleading in a professional sense at all. I hope Mr. O'Donoghue understands that and the court. But it is incomplete, and that's why I'd like you to...
Incomplete would be perhaps be a less emotive word that covers the point.
Yes. I accept that.
Right, good. You're both sitting down now, so I can take this opportunity to thank the parties and their solicitors for their comprehensive arguments and to say that we will take time to consider our judgments. We'll hand them down in the usual way, asking for typographical corrections only, and thereafter we ask that you agree costs and an order for disposition of the matter according to our judgment. If you can't agree, we'll deal with the arguments on those points in writing.
All rise.